Three Afghan-Canadians are planning to sue the federal government over what they say is an unfair exemption provided to Ukrainian refugees. The Canada-Ukraine program expedites the immigration process by providing temporary status to Ukrainian nationals and their family, allowing visa holders to travel, study, and work in Canada for up to 3 years. That's much longer than the usual 6-month stay given to other refugees. The program also waives fees and gives priority to Ukrainian refugee applications. Nicholas Pope of Hamid Law is one of the lawyers who is representing the three plaintiffs. He's our guest this morning. Good to have you here.
Good morning.
At the crux of this case is Section 15 of the Canadian Charter, which provides equal protection and benefit of the law. Why do you believe your clients believe that the immigration pathway provided to Ukrainian nationals and their families is a violation of Section 15?
Well, we don't have any issue with the government providing extraordinary help to Ukrainians in an extraordinary time. But the issue here is that this program for Ukrainians was based solely upon nationality, not upon emergency needs. So Ukrainians who have been living outside of Ukraine for, say, 10 years, maybe in the UK, and are not in danger, were allowed to enter the country through this pathway. By contrast, our clients who were language and cultural advisors working for the Canadian military and for the NATO mission. And because of their work with Canada, a target was put on them by the Taliban, and their families in Afghanistan are at risk. One of their family members have been killed on their way to work, and they've received threatening phone calls saying that they're going to be killed because of their involvement with the Canadian military. And Canada worked very hard to make sure no Ukrainian fell through the cracks. They eliminated all sorts of normal restrictions and red tape that might make it so that one Ukrainian might not come to safety. But they didn't do the same for my clients, despite the very special and unique relationship here, where my clients' family members are at grave risk because of the service to Canada.
Can you talk to us a bit more about the risks that they are facing?
So one of my client's sisters, who was in Afghanistan, she was receiving phone calls about every week for a few years. And this was before the Taliban even took over. But she was receiving these phone calls with threatening messages saying they're going to kill her because of her brother's involvement with the Canadian military. Eventually, one day, her husband, on his way to work, was shot and killed. And so they fled to Turkey. And because they fled to Turkey before the fall of the Taliban, before the Taliban came back into power, they're not eligible under the program that was given to help assist these language and cultural advisors' family members. But they're still in grave risk. They still may be deported back to Afghanistan at any time, and they're not safe there.
No. You know, a lawsuit and awaiting a court date is not going to be able to bring people's family members back to Canada any faster. So what solutions are you hoping the government will offer in the meantime, or what are you hoping will happen out of this lawsuit?
We're hoping for two things. First is for the family members of my clients. They need an immediate solution. Even in the year since this court case was filed, there's been more harassment, more threats, more people going door to door looking for these family members. So we call on the government to do something to help. It's only a few dozen people who need assistance here, who fell through the cracks. Give them some sort of solution, some sort of pathway to safety in Canada, because we owe it to them. The second is we see with the Ukrainian program here that these special benefits were only provided to Ukrainians. And actually the internal memos we just saw from the government said the reason for this is Canada's unique relationship with Ukraine, and that it was an invasion of a country adjacent to the EU. It shouldn't be based upon where in the world the country is located or whether it's located in Europe. Assistance should be provided equally to all people in equally dangerous situations.
One last question for you. We did reach out to Immigration, Refugee and Citizenship Canada for a response. A spokesperson provided this to us. Canada tailors its response to each situation to meet the unique needs of those who require our support. Afghans were fleeing those in power in their own country and required a permanent protection solution. The purpose of the Canada-Ukraine Authorization for Emergency Travel Public Policy, that's what it was called, was to offer temporary safe haven in Canada from the conflict, and it was uncertain when the Ukrainian clients could return home. What's your reaction to their explanation?
That doesn't hold any water. The court recently ordered production of the memos underlying the decision to issue the Canada-Ukraine Authorization for Emergency Travel. And in those memos, we see that the department is trying to create a solution that will allow Ukrainians to move here permanently. In fact, the Minister of Immigration, against the department's advice, required that the requirement that Ukrainians have temporary intent, that is intent to leave Canada after 3 years, be waived. And Immigration Canada said this could undermine our whole system because it turns the temporary residency program into a second-class permanent residency program.
Right.
Despite that, the immigration minister made that change. So there's actually not a functional difference here between the two pathways. Both are permanent pathways.
Nicholas Pope, I want to thank you for your time today. We'll continue to follow this story. Be in touch.
Thank you.
Hey, thanks for watching. If you liked this, be sure to subscribe here, or you can check out more Your Morning videos right here.